Good afternoon, everyone. Thank you so much for joining our final webinar of 2021. Can you believe we're already in December? Wow, that went really fast for me. I don't know about you. And with that, we're going to just go right into the webinar information. John Kamin is leading today's training with a 2021 legislative and regulatory update. Louis Laris and Zane Uriberry are going to be assisting John today. If you haven't heard, we have a new website at bradfordbarthel.com. If you need additional CE credits, PD ratings, updated workers' compensation news with our B&B blog, or if you just want to see our new attorney profiles and pictures, do visit our website. We have it all there. And then we're going to, I think, launch into some introductions. Tamina, would you like to start us off?
I would love to, Tammy. Thank you so much. I'm in Woodland Hills, folks. My name is Tamina Ahmed. You all know me as Tia. I've been with the firm for approximately 24 years as of December 13th. So my anniversary is coming up and the firm's anniversary is coming up in January. We will be celebrating our 25th year this coming year. With that, I want to tell you, I am very grateful for your participation. I am very grateful to be partnering with all of you. I see so many familiar names on the attendees list, which is now up to 279 attendees. So thank you all for joining us and being with us this entire past year. We look forward to hopefully seeing you all in the near future. With that, I'm going to pass it on to Rob.
Good afternoon, everyone. This is Rob Safkus. I practice at B&B office up in Reading. I've been practicing workers' comp defense for over 30 years now. Seems like time flies. I've been with B&B now for going on 8 years. I was working at Los Angeles office for a long period of my career, so I have had experience at all boards across the state. Well familiar with the procedures, the judges, the doctors, all around California. So if anyone has any questions at any time regarding procedures or doctors at any location, or especially up here in the Northern California area, I'd be happy to answer any questions. Look forward to working with everyone. Thank you. And with that, I'll pass it on to Keita.
Good afternoon, everyone. My name is Keita Middleton, and I am with the Woodland Hills B&B office. I've been doing workers' comp close to a decade now. And just a fun fact about me, I can greet in 8 languages.
Nice.
Thank you.
Good afternoon, everyone. I'm Zane Uriberry. I am from the Ontario office. I'll be assisting with some questions and jumping in a little bit to kind of talk about some things that we've seen with COVID-19 and how those claims have gone so far. Always happy to answer questions. You see our emails are here, but another one I want to give you is covid@bradfordbarthel.com. You can use that email to send us questions that you might have on COVID claims, whether something is a COVID claim or how to deal with any of that legislation. Always happy to help. And with that, I'm going to go ahead and pass it to Louis.
Thanks, Zane. And good morning, everybody. Like Zane said, my name is Louis Laris. I'm with the Fresno office of Bradford and Barthel. I've been with the firm for a little over 20 years now. And in addition to being an equity partner, I also am part of the head up the appellate division for the firm. I've argued cases from the courts of appeal throughout the state, as well as the Supreme Court. And so I'll be bringing some of that experience to bear on the discussion today, especially regarding the Dynamex case and the ABC test. And with that, I'll turn it over to our star of the show, John Kamin.
Thank you so much, Louis. And yes, Louis is definitely a great person to ask about any case law. Louis, I think I've known you now for more than 10 years since I was a journalist at Work Comp Central. And I was asking Louis questions about Alvarez Guzman. And I think that's when I met Tammy as well and Don Barthel as well. So I hope everyone's having well, I hope everyone had a great Thanksgiving weekend and also is having a great holiday season. Speaking of the holidays, I did sprain my ankle while getting the Christmas tree the other day. But if Tom Bradford or Don Barthel happened to ask you about that, just tell them it happened while I was lifting this really heavy PowerPoint presentation, okay? Now, I am out of the Woodland Hills office, the same office as Keita and Tia. And I'm a partner and director of the editorial department, which is a fancy way of saying that I run the firm's blog with the help from our wonderful team. Now, before I was an attorney, I was a journalist, legal editor at Work Comp Central for about 6 years. And there I summarized all the court decisions and new work comp legislation in all 50 states with a focus on California. And before that, I was a reporter and editor for a few Arizona newspapers. So if you happen to forget any details of today's presentation, please note that we do have blogs on our website, and we'll be posting a blog soon with the content of this presentation. And the blog is bradfordbarthel.com/blog, or just Google it and it comes right up. We average about 1 new blog post a week, so it's not a bad place to check out if you're trying to find out more about work comp defense. And with that, let's get rolling into the presentation. Here's some of the topics we're going to cover today. Approved bills is how we're going to start the presentation. So we'll first cover SB 331, which tackles general releases. AB 1511 talks about cancellation of coverage and some of the timeframes involved with cancellation notices. AB 1561 is ABC test exemptions. And SB 606, Cal-OSHA enforcement. Next, we'll talk about failed bills and what to look forward in 2022. After that, we'll take a look at COVID sick leave strategies, and then the copy service fee proposal as well. So let's get started and dive right in. So SB 331 is the Silence No More Act. This was signed into law by Governor Newsom a few months ago, and it takes effect on January 1st, so about 29 days, 30 days from now. And what it does is it bans specific non-disclosure language in general releases. So when do you use a general release? Well, for work comp purposes, it usually comes into play when the parties are doing a compromise and release with a general release. And the general release often contains a multitude of provisions and often contains a non-disparagement clause. And that typically bars employees from going to the media about their version of events at what happened with what happened at the employer. Now, please note that this bill does not eliminate non-disclosure or non-disparagement clauses, but it does require specific language, and we'll get into that in this slide. So the bill requires concrete language that notes the applicant's right to disclose information about unlawful acts in the workplace. And it requires this following sentence, which is in quotes on the middle bullet point there. And you want to add that sentence to your general releases. So nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you have reason to believe is unlawful. And so the bill and the statute specifically mention that sentence. And so you literally just want to copy and paste it into your general releases. So what does that sentence mean? It means that employees can still disclose factual information about any type of harassment, discrimination, and retaliation, despite your general release with a non-disclosure clause, and despite the settlement. So where did this come from? Well, a few years ago, SB 820, the stand bill, barred NDA clamps on employees talking about gender discrimination. And so this bill expands that NDA ban on gender discrimination to prevent general releases from barring employees' ability to talk about unlawful harassment, discrimination, and retaliation within the workers' comp genre. So just to be clear, you can still do general releases with CNRs, and you can still include voluntary resignations, and you can even still use NDAs. You can NDA or non-disclose trade secrets or things that are clearly untrue. So anything disparaging, defamatory, libelous, that kind of stuff, and information that's crucial to the company's development or strategy, that falls under trade secrets. So you can still clamp down on that kind of on employees' ability to go talk to the media about that stuff. So let's move on to our next bill, AB 1511. and this impacts timeframes for notices of cancellation of coverage. Now, existing law requires carriers to send notice of cancellation either 10 days or 30 days prior to canceling a policy. I know that sounds confusing. I'll get into the 10 versus 30 in a few minutes. So this bill expands those timeframes by saying that those timeframes should add 5 days if mailed in the state of California. So if you're mailing the notice to someone in California, it now moves it to 15 or 35 days. If you're mailing it to somewhere else in the US, add on 10 days to these timeframes. And if you're mailing that notice of cancellation outside the country, add 20 days. And I think part of this may be due to the slowdown at USPS or the US Postal Service. And it's also intended to give employers more notice or a better chance of receiving timely notice that, hey, your work comp policy is going to be canceled. And so when does the 10-day apply? The 10-day applies, so basically the notice to give notice either 10 days prior to canceling a policy. That applies if the employer has failed to pay their premiums, failed to report payroll or allow the carrier to audit payroll, or failure to pay additional premium based on a payroll audit. The 10 days also applies if the employer made a material misrepresentation. Sorry, that's a typo on my part right there. So if they made a material misstatement, so something that's really important, they misstated or misrepresented. And the fourth reason is if they failed to cooperate with the carrier's claim investigation. That's another reason you can cancel a policy. So the 30 days notice before you can cancel applies when an employer has failed to comply with federal or state safety orders or the written recommendations of the carrier's loss control department. And the 30 days also applies when a material change in the policyholder's business dramatically increases their level of risk. So if their XMOD goes up because they took on a whole bunch of new business and new duties, that could also be a reason for canceling the policy because there's been a big increase in risk. So our takeaways from this bill as far as practical stuff that you as workers' comp practitioners want to know, if you're canceling a policy, earlier is better because these timeframes are going to apply and they're going to potentially delay your cancellation of a policy. And if you have canceled a policy and have some claims around the time of cancellation, check where and when the notice was sent to and add the appropriate number of extra days, which are 5 days if in California, 10 days if you're sending it to someone elsewhere in the US, and 20 days if you're sending it to someone outside the US. And I have seen this make a difference. These 10 to 30 days make a difference on whether coverage existed. For instance, I've seen a specific date of entry and then a retroactive cancellation of coverage. So you want to really keep an eye on these timeframes if you are seeing those types of issues with the co-defendant or on your own end as it pertains to a specific date of injury or even the end of a CT, because that stuff can be really important when determining liability. Now, AB 1561 was another bill that Governor Newsom signed into law. And what this does is it makes changes to the exemptions on who the ABC test applies to. So first of all, what's the ABC test? That test says that if the worker does not meet any of these three conditions, A, B, or C, if the employee doesn't meet all of those three conditions, then they're an employee for work comp purposes. So, and this comes from the state Supreme Court case in the Dynamex that came out in 2019, so a few years ago, or 2018 actually. And then AB 5 or Assembly Bill 5 is what codified the ABC test into law. So A is if the employee or if the worker was free from the control and direction of the hiring entity in connection with the performance of the work. B is if the worker performs work that is outside the usual course of the hiring entity's business. And C is if the worker is customarily engaged in an independently established trade, occupation, or business. And so the thing about the ABC test is that it basically makes it easier than the old test to have a worker classified as an employee for work comp insurance purposes. And it's that B factor that transforms most workers into employees. Now, AB 1561 makes minor changes to who's exempted from the ABC test. So for basically under the statute, there's a long list, a very long list. It's literally hundreds and hundreds of jobs long and types of jobs long that says the ABC test doesn't apply to these groups of people. Instead, you should use the Borello test, which is the right of control test that we've been using in California work comp for about 15, 20 years now. So you want to use the Borello test for claims adjusters, data aggregators, and licensed manicurists and so the licensed manicurist, you're using the Borello test up until January 1st, 2025. And that's if those licensed manicurists meet certain conditions, such as basically controlling their own business. They set their own appointments, set their own rates. They don't have someone else telling them, hey, you're going to set appointments on this day and this day, or your rate's going to be this or that. As far as the claims adjusters and data aggregators, you're just using the Borello test for good. And Louis, I think you have some more to say about this one.
Yeah, John, thanks. So I think it's important to bear in mind that Dynamex didn't originate at the WCAB level. It's actually a wage and hour case. And but there's of course issues that dovetail with wage and hour cases and workers' compensation cases, like this distinction between independent contractors and employees. And so there is some crossover. And then of course you have AB5 and the subsequent cleanup bill 1561, which is designed to clarify what exactly is or which test applies to what type of employee. And in preparation for today, I did some research in Lexis just to see how many WCAB decisions at the recon level and above have addressed or applied Dynamex. And surprisingly, I only found 7 in the 2-3 years since the Dynamex case came out. And some of those weren't even directly addressing that issue of independent contractor versus employee status. So it was sort of an ancillary issue. But I still think there's some confusion on the part of the board and certainly on the part of trial judges probably as to which test would apply, whether it's Borello or whether it's Dynamex or the ABC test. And so thankfully this bill clarifies that. But again, it's going to be on the burden is going to be on the defendant really to know what's in that legislation and which jobs or occupations are exempt from the ABC test, because the ABC test is a little more applicant friendly perhaps, but not to give Tia an excuse for more marketing material, but perhaps a flow chart outlining the types of occupations and which test might apply would be a handy little cheat sheet to pass around to assist in making that determination.
And Louis, excellent points. When I was originally summarizing AB5 and all the exceptions where they say the ABC test doesn't apply to these jobs, instead use Borello, the list was so long I was going to have maybe a 10,000 word blog. So it's a very, very long list. And so that's why we aren't listing them all here for the audience, just so you as the audience know. It's literally too much information to sit down and read. So it's the kind of thing where if you are confused about it, well, Louis does make a good point. You as the defendant, so defendants are going to be the ones who are going to want to know, does the right of control test apply or does the ABC test apply? And if so, if you can use Borello and the right of control, that's the test you want to use. So what I'd recommend doing is go to the statute, hit Control F and type in the job and go to that section of the statute. It'll save you reading 1,000 words of extra stuff you don't have to read. And you can literally see if they're exempted very quickly. So unfortunately, it's that long of a list, but Control F will help you find whether someone like a claims adjuster, for example, is exempt from the ABC test and you would apply Borello instead. Now, some of you also may be thinking, gee, didn't last year's proposition undo the ABC test? Well, it did for drivers for Uber and Lyft and for cell phone applications. But for everyone else, for example, truckers and trucking companies, last year's proposition did not remove them from being subjected to the ABC test and what we're talking about here. So just to be clear, last year's proposition only applied to people who drive for cell phone application companies. And that's my reason for mentioning that is that's often a common point of confusion as well. All right, let's move on to our next slide. So SB 606, another thing we've seen in the last 2 years is a lot of Cal-OSHA enforcement, a lot of Cal-OSHA fines and violations. So with that, I wanted to make sure we covered SB 606 because with the prevalence of COVID-19 these days and a strict set of Cal-OSHA COVID-19 rules and regs that employers have to abide by, I think employers are definitely going to want to be aware of this bill that's strengthening Cal-OSHA enforcement by stating that for employers with multiple work sites, let's say you have a construction company with 20 work sites, this bill makes a rebuttable presumption that if there is a OSHA violation at one work site, it's presumed that the violation is happening at the other 19 work sites as well. Now, it is a rebuttable presumption, but that being said, for that employer with 20 work sites, they're going to want to be aware that, hey, we need to show OSHA that OSHA violation of that one reg was only at that one site and not all 20. So why is that important? Well, if OSHA issues an order for specified safety requirements across all 20 work sites, that could be far more burdensome than just issuing an order for just the one. And my personal opinion, if OSHA issues an enterprise-wide monetary penalty for all 20 work sites, that's probably going to be a lot larger than if it was just for the single work site, a single violation at a single work site. So employers, if you do get hit by Cal-OSHA, yeah, this is something you're going to want to be aware of. 606 does some other things too. It also requires Cal-OSHA to issue a citation for an egregious violation for each willful and egregious violation. And what that alludes to is in the past, they weren't always doing that apparently. Each instance of this violation would be considered a separate violation for purposes of fines and penalties. What does that mean? It probably means larger fines and larger penalties for egregious violations. Now, this does not apply to certain state departments, such as the Department of Corrections and the State Department of State Hospitals as well. So if Cal-OSHA is required to issue a citation for a egregious violation for each willful and egregious violation, it makes sense to understand what is a egregious violation. Well, that means that the employer intentionally made no reasonable effort to eliminate a known violation, or if the violations resulted in fatalities or a worksite catastrophe, or a large number of sick people. By the way, the definition of a worksite catastrophe is if you have 3 or more employees hospitalized from an injury. Another factor that could set up an employer for an egregious violation is if they have persistently high rates of injuries or illnesses. Another one is extensive histories of violations and intentional disregard of health and safety responsibilities. So I can imagine what you're thinking. A lot of this is screaming, follow the COVID-19 regulations from Cal-OSHA, which we've written about on the BNB blog, by the way. SB 606 also strengthens Cal-OSHA's ability to enforce the regs by authorizing Cal-OSHA to issue subpoenas if the employer ignores them or doesn't provide requested information. Cal-OSHA can also request injunctions restraining an employer's operations. And it also expands Cal-OSHA's grounds to seek a temporary restraining order. So our takeaways with SB 606 is that Cal-OSHA can essentially stop an employer's business in their tracks. They can also assess large financial fines. They can stop the business in its tracks with the temporary restraining order and injunctions and orders to for the employer to follow certain behavior or remedy certain things. And then the financial penalties can be quite steep. We've seen them be larger than $100,000, for example. So this definitely seems aimed at employers who are totally ignoring the Cal-OSHA COVID rules and regs. And so if Cal-OSHA does come after the employer and shuts them down and the employees can't work or get paid, what do you think they're going to do? They're probably going to file for EDD, and some will probably file work comp claims. Some may even file S&W claims. So long story short, do your best to keep your employees safe if you're an employer, and try and follow the Cal-OSHA regs as far as COVID, because this bill does really seem aimed at employers who are just ignoring COVID rules and regulations. Now moving on to AB 654. This one clarifies that there is an outbreak, and I think we're missing a slide. So I think we are missing a slide somehow, but I can summarize this bill. AB 654, in short, states that a employer must give notice to a local public health agency within 48 hours or 1 business day, whichever is longer. So if there is a COVID outbreak, they have to notify, usually it's the county health department, within that 48 hours or 1 business day. Now, the outbreak definition under this law, it's not the same as the definition under the work comp presumption. Under this one, it's 3 or more lab confirmed cases of COVID-19 among workers who live in different households within a 2-week period. So exempt from the outbreak reporting requirement are community clinics, adult day health centers, community care facilities, and child daycare facilities. So that is a rather large swath of businesses there that are exempted. But if you aren't on that list of exempted businesses and you do have a COVID outbreak at your workplace, you do want to give the county health department notice of that outbreak very quickly. 48 hours isn't much time. Now, other bills that were signed into law during the 2021 session are SB 823. This is a large bill that does have one little provision that applies to work comp, and that little provision exempts anyone who reports a fraudulent claim from civil liability. And it specifically lists carriers, employers, judges, attorneys, as long as they acted in good faith without malice. And so if anyone on that list, anyone who does report a fraudulent claim does get sued in Superior Court, I would imagine that you would file a demur citing the statute listed in this bill as they have failed to state a claim. Now, AB 1541 would allow SIGA to issue up to $1.5 billion in bonds to cover insolvent claims. AB 845 allows state employees to get disability retirements if they get COVID during an outbreak at their place of employment. SB 321 requires Cal-OSHA to form an advisory committee on privately funded household domestic service employees, and they have to issue a report by January 1st of 2023. So in other words, they have to get that report out within the next 13 months here. AB 701 would force employers of 100 employees or more at a warehouse to provide each employee with a description of each quota. So all these bills were signed into law during this session. And my reason for clarifying that is next we're going to talk about SB 1159 a little bit, and then we'll go into failed bills. But everything we've talked about so far in the presentation are bills that have been signed into law, and they either are law now or will be taking effect on 1/1/22. One other thing to keep an eye on as we move into the next year is SB 1159. That is the COVID presumption bill that was issued in September 2020. And this has 3 presumptions. And under this bill from 2020, the last day of work is the date of injury. And the presumptions don't cover people solely working from home. But guess what? This bill expires on January 1st, 2023. Again, that's 13 months from this presentation. So we're going to keep an eye on the legislature and see if they decide to renew it. And if they do, we will definitely have that on the blog, and we'll probably have a webinar next year about that as well. And Zane?
Yeah, I just wanted to touch real quick on some of this because we do have about 13 months until this law actually expires, and then what's going to end up happening. So let's look at what we've seen so far. What we see largely when claims are filed that are COVID claims, they're largely denied, and they're usually denied because there is no outbreak. So something to think about is that if this bill is renewed, it may be renewed without the outbreak provisions. Some months there are a lot of claims, and some months there are a lot of employers that have a lot of individuals that are sick at the same time. But during the summertime, we saw as few as 770 claims actually filed with the at the board for COVID injury statewide. So there's not very many, and even now it's down to 3,600 as of October. So the numbers are quite low, which makes it very unlikely that there will be a presumption, which means that individual applicant attorneys have simply been trying to go around the presumption. So even if this bill is not renewed, expect that to continue, continuing to maintain that they can prove that an individual contracted COVID at work due to some kind of direct exposure. There are usually cases that are denied have this allegation made in them. They are not always very successful. So that is something else to kind of think about and look at as we're going along. I don't expect these claims to entirely go away, but I do expect these claims to kind of be the kind of claims that are added on to something like an orthopedic claim. So if an individual has an orthopedic claim and then they did have COVID earlier in the year, we're starting to see a lot more of that, a lot more COVID claims being added on to orthopedic claims. And the reason for this is because as time goes on, and as we have more and more evaluations that are being done by medical legal evaluators, QMEs, we are starting to see that the level of permanent disability that individuals have is very low to non-existent. Most reports that I get back have no impairment at all. Many reports also that I get back also say there's no need for future medical care. And suddenly the cases that I think were thought to be, you know, very high value cases, not so much anymore. So we may not see as many of these cases coming up on their own. They may just be kind of cases that are added on to existing orthopedic claims. So they won't be going away, but definitely something to think about as we go forward.
Excellent point, Zane. And yeah, to your point, you know, one area or one body part where you can see a intersection of orthopedic allegations and COVID is COVID toe, as Aaron Rodgers may tell you. So yeah, Zane's a big football fan, so I wanted to just throw that in there. Now, another thing we want to keep an eye on in 2021 another thing we want to keep an eye on in 2022 is the failed bills from 2021. And why do we care about failed bills? Well, because similar versions of these bills tend to resurface, like The Walking Dead, in the years ahead. So sometimes things evolve, sometimes they change, sometimes they try and pass the same bill with the same exact language, but usually they change a few things. So for some of these bills which failed, the end goal may be the same, but they may change the language or some of the requirements in hopes of, well, if the governor vetoed the bill last year, maybe these changes will get it past his desk in the next year. So some of the bills that failed in 2021, and just to be clear, everything on this list was not approved. It will not be law next year. But some of the proposals were a proposal to create a statewide NPN. That language was removed by lawmakers from that bill. Another one was to reduce the decision timeframe from the current 90-day timeframe down to 45 days for most claims. That bill died in committee. Another proposal called for first responders presumption claims to have a 30-day decision timeframe. That died in committee as well. Another proposal was to hike the monetary cap on medical treatment during that decision timeframe from 10 grand up to $17,000. That was also edited out in committee. Firefighters, another proposal suggested that firefighters should get up to 1 year of salary continuation benefits for industrial injuries after 1/1/22. That was also not passed. Another proposal was to really increase EDD payment rates, which would have meant that from your paychecks, from my paycheck, your paycheck, everyone on this call's paycheck, we would have had to withhold more money for the EDD tax. And then the employers also would have had to contribute more to EDD. In exchange, the people who do collect EDD would have seen higher rates. So instead of EDD paying about 2/3 or 60% of their average weekly wage, is going to be cranked eventually up to about 70 and even as high as 90% of their average weekly wage. So that was vetoed by Governor Newsom. As you can imagine, coming into an election year, he wasn't trying to shrink people's paychecks by approving this bill. Because again, we would have had to withhold more money and pay more money in EDD tax from our paychecks. So not exactly a popular thing for a governor who's trying to get reelected. Another proposal lacked the votes to require the medical legal fee schedule to be updated every 2 years. And that's important because they did just update the med legal fee schedule this year, as many of you know. So with the cost rising on that, there is less incentive to require it to be updated every 2 years. Another would have created PTSD presumption for firefighters. Now that bill was inactive, it was held over to 2022, so that still could be considered next year. Another proposal, which was vetoed by the governor, would have barred apportionment of permanent disability to race, religious creed, color, national origin, gender, marital status, sex, sexual identity, or sexual orientation. And another bill that didn't make it through this year, but could make it in 2022, is a skin cancer presumption for departments of Fish and Game and departments of Park and Rec. In other words, for state employees who spend a lot of time outside. Now, one of the failed bills that attracted a lot of conversation was the statewide MPN. And so I wanted to cover this because this did receive a lot of press earlier this year. Now, if everyone is allowed into a statewide MPN, and what I mean by everyone is if every physician is in the statewide MPN, then does it really have a standard of care? It probably doesn't even have one. If everyone can just get into the statewide MPN, then there is no heightened standard of care for having that MPN. So that's one reason not to have a statewide MPN. You want to have some higher standard of care standards, so you don't have doctors, butchering patients. Another reason why this bill failed is, I believe it was CWCI who stated that it would create an additional $314 million in annual costs for defendants by eliminating the contractual MPN discounts. And I noticed that shortly after that, that is when this bill failed. Another argument against it is that it could destroy continuity of care. And where that comes from is if you have an existing claim today, and let's say you did have a statewide MPN imposed next year, and that applicant's lawyer says, hey, we want you to treat with this different doctor. Well, suddenly they're treating with someone who doesn't know their case very well and doesn't know their body parts very well. And so it destroys that continuity of the PTP's knowledge of the applicant's case. And lastly, the DWC would probably have to create and adequately staff a new department to monitor and administer that statewide MPN. And that might not be so easy for the DWC to do. So that's another reason not to have one. So those are some of the reasons why that bill failed. Another bill that received a lot of press and also failed in 2021 was the one to shorten decision timeframes. And the reason why shortening the decision timeframe or the delay period, the reason why that's a bad idea is if there's less investigation time for defendants, then you're going to have more denied claims. And that actually conflicts with the goal of the bill, which was to create more accepted claims. So if anything, logically speaking, increasing the decision time frame to a period longer than 90 days would probably lead to more accepted claims. And another reason why that bill failed is it could increase costs for state and local governments. So if you shorten the decision period and you have claims that are denied that should have been accepted, but there wasn't enough investigation time, that could increase cost on the back ends for your local counties, cities, and municipalities. So what lies ahead in 2022? In 2022, we're probably going to see some of these, some of the proposals listed below if COVID keeps on persisting. So as Zane noted, if the COVID numbers stay low, then we probably aren't going to see a renewal of SB 1159 and its 3 presumptions. But if COVID numbers jump back up, thanks to Omicron or other types of COVID, then we could see SB 1159 and the presumptions renewed by the state legislature. Also expect Cal-OSHA to get stronger if COVID persists and employers are ignoring the COVID regs. We could also see proposals for vaccination legislation for employers in general. We also may see some proposals regarding employer testing for COVID. In general, 2022 is also probably going to see some more anti-apportionment bills, bills proposing increases to the OMFS and the med legal fee schedule. We could also see increased penalties for wrongful denials of presumption claims. Again, currently that's $10,000, but there has been interest among some lawmakers to increase that up to $25,000. I know earlier I mentioned $17,000, but in the discussions during one of the hearings, they talked about increasing it up to $25,000. So that could also be something we might see in 2022. Another thing we might see next year is a creative proposal to try and help applicants get outside the NPNs. As we just talked about, there's a statewide NPN proposal. In years past, there have been other bills that have failed. And lastly, perhaps more action from the DWC on the interpreter's fee schedule. In 2022, litigation-wise, we could see more cases with AOE, COE issues with fact patterns where you have employees working from home, bad reactions to vaccines, and also cases where there's employer and government mandated COVID testing. Now, next year, we don't really anticipate that it's going to be a big reform year. It could happen, but it seems like 2023 is the year where that's most likely to happen. And my reason for saying that is during one of the committee meetings, Assembly Insurance Committee Chair Tom Daly from Anaheim hinted that if Gavin Newsom wins this year's general election for governor and gets a second term, then there could be significant work comp reform in 2023. And here's Daly's quote: "We will be living with work comp reform in the coming months and years." And he is saying that in reference to if Newsom wins this year. And as you know, Newsom just won the recall election pretty easily. So odds are he could easily win the 2022 general election. So keep an eye on the governor's race this year, as it is important for what types of bills are going to be proposed 2 years from now. Now, another area which we've had a lot of questions on is California's COVID sick leave. And as some of you know, the sick leave bill making it mandatory for employers to pay COVID sick pay expired on September 30th, 2021. And there is no replacement legislation on the horizon right now. So what does that mean? What happens if someone gets exposed or gets sick from COVID? And when does the employer have to pay, continue paying sick leave or COVID sick leave, and when do they not? Well, the Cal-OSHA regs say that if someone has an industrial exposure to COVID, then the employer should continue to pay them while they are out sick. So if Jim is working next to Tom, and Tom has COVID, and then later figures it out and gets a positive test and tells the employer or tells Jim, then that would be a work-related exposure. So under the Cal-OSHA regs, in that situation, the employer would have to pay Jim as if he is still working there while Jim is out on quarantine, while Jim is out on quarantine. Now, local governments have COVID sick leave as well, regardless of the type of exposure. And so these include LA City, LA County, Long Beach, Oakland, and San Mateo County, the unincorporated areas. So those governments, they also have rules saying that it doesn't matter what the source of the exposure is. If the employee is out on COVID quarantine for 10 days, then the employer should continue to pay them COVID sick leave. And usually, if you look at those rules, they say that the employee gets up to 80 hours of pay or 2 weeks of pay. So let's just look at the sick leave analysis. If there's a work exposure to COVID, and so if Jim, again, is exposed to COVID at work, the employer picks up the sick leave under the Cal-OSHA regs. Now, if that work exposure turns into a work comp claim, then the carrier can pick up the TTD while Jim is out. But what if the COVID exposure is not work-related, as in Jim's COVID exposure occurs at the grocery store? which is not where he works. Well, then check and see if your local government, like LA County or San Mateo County, has a local sick pay regulation. If they do have a sick pay regulation, then yes, the employer should pay the sick leave. If they don't, then the employer does not have to pay the sick leave. So what if there is no sick leave? What's the employee supposed to do? Well, they still have other options. If there is no sick leave provision in the local municipality and the exposure was at some place outside the workplace, well, there's always state mandated 3 days of sick leave. They could also exhaust sick time, PTO, or vacation time, and they could also request EDD. And these sick leave questions really depend on the facts that are unique to each situation. So if you do have an unusual situation or are confused, feel free to ask us. Again, the COVID@BradfordBarthel.com email address sends it directly to our COVID response team, and we can address any sick leave questions that you have. Also keep in mind that it is possible that next year someone proposes additional legislation that reinstates the COVID sick pay requirement for all of California, especially if cases do spike again with the new variants. Now, while we're talking about COVID, I figured I'd throw in some CWCI stats. That's California Workers' Compensation Institute. They reported that COVID claims dropped sharply in October. Originally, so CWCI had projected 3,621 COVID claims for October 2021, and those are still coming in, so that's why it's a projection and not an exact number. But that's down 56%, so it's down a lot from the 8,197 claims that CWCI had projected for August 2021. And if you want to read more about that, CWCI had a great, very detailed press release at that link down there. That press release also pointed out that the Central Valley now has the highest proportion of COVID claims since February 2021. And they compared several geographic areas. Another geographic area they compared is San Diego, LA County. LA County's numbers have dropped. So have San Diego's. Well, San Diego's numbers have always been low though. And so that is surprising as that is a tight urban area. But yeah, San Diego County has always had a low amount of COVID claims. Now, we have had just under 170,000 COVID-19 work comp claims that have been reported since the start of the pandemic. And again, if you want to read more details about that, there's the CWCI press release there. Earlier this year, the WCIRB noted that the total written premium in the state had also dropped significantly. There is $600 million less in premium written in the first quarter of this year compared to the first quarter of 2020. And the reason for that, fewer businesses as the economy contracted due to the pandemic, and also a smaller workforce as some businesses shut down, other employees left, and as you've heard undoubtedly through the news, some restaurants are having difficulty finding employees. So we, in general, just the workforce has contracted a little bit. Now, shifting gears to our last topic for today is the copy service proposal that's currently pending at the Division of Workers' Comp. And so I want to be clear, this is still just a proposal, but the main takeaway is that it would increase the standard rate for subpoenaed records of 500 pages or less from the current rate of $180 up to $225. Copy service bills would be paid, have to be paid within 30 days under this proposal by the TPA. And if it isn't paid within that 30 days, then the unpaid balance would increase by 25%. The DWC copy service price schedule, and they've changed the name. It used to be the fee schedule, but now they're calling it the price schedule. Also says that copy services cannot get paid for services that were provided within 30 days of a request for records on behalf of an applicant from an employer, administrator, or carrier for their records. And why 30 days? That 30 days is intended to create a time frame for defense counsel to meet and confer with applicant's attorney about those records. And so here are the meet and confer requirements you want to keep in mind if this proposal is approved by the Office of Administrative Law. So if you as a defense attorney receive a notice of intent or a subpoena to copy records from an employer or TPA or carrier, you want to object. And then that leads to the meet and confer period. And again, that period is 30 days. Now, one topic during the recent, so they had a meeting to talk about the proposal. And it came up as to whether that meet and confer period was good or bad. In my personal opinion, I think it's probably good, as it will ensure that bad actor copy services can't just sidestep defense attorneys. And I can personally attest that I've had some copy services never serve me with a subpoena, but then send us the bill later, despite me having a valid notice of rep and clearly being a party of record on the Eames address record at the time. So again, they had a hearing on this proposal back on August 30th. Not everyone could log into the Zoom meeting. So some people called in, but there's still questions as to whether everyone was able to attend. And in order to get approved, this proposal has to be submitted by the DWC to the Office of Administrative Law, or the OAL. But I just checked a few days ago and they still haven't done that. So the fact that they haven't submitted this to the OAL for approval means that they're probably going to take another crack and revise them and put them up for public comment again next year. And so with that being said, Louis and Zane, do we have any questions from our audience?
Thank you, John. I think they're coming back on now.
Yeah, I mean, we do have an interesting question here. So I'll read it to you. This one is from Armin. We've been receiving copy service billing, which includes tax. Do we have any defense against this?
Yeah, I think your current defense is the fee schedule itself. And so if you want, Armin, you can email me directly and I can send you a link to the current fee schedule. But yeah, I think just the straight regulatory language from the current existing regulations would be your defense to that. And my reason for saying that is that the current regs do mention specific reimbursement rates. So yeah, I don't remember seeing anything about tax in there.
I think tax is separately reimbursable, but I think your defense is couched in terms of the underlying liability. If you can attack the heart of whether it's a valid legal cost, I think that's really your only defense to the tax issue.
Okay, I think we answered all other questions, or is there any more? Zane and Louis?
It looks like there's three more that popped, or actually, yeah, three more that popped up. You're welcome, Armin. Let's see. Any defense against Ideal Medical, getting bills from them, they send medicals to Maximus, which we're already required to do. Oh, so yeah, so it sounds like, is it a valid med legal expense if the applicant's attorney subpoenas medical records and sends them to Maximus if you're already doing it? That's from Tammy.
Not this Tammy, but another Tammy.
Sorry, Tammy.
And I also see a question from Chris that says, so when they request our file within the first 30 days, we should not be charged $75 for cancellation fee. Well, again, that's just a proposal, the proposal I was just talking about. So currently that meet and confer requirement still does not exist, but there's many defenses against whether that subpoena should have even been issued. So for example, was it even necessary? Was it something necessary to prove or disprove a medical fact or just a regular fact to help decide the claim? So I think you can always use that against those canceled subpoenas. And also if the applicant attorney didn't ask for it first and they just sent out the subpoena, that's another defense against copy service subpoenas as well.
Okay. Anything else? Are we good?
Okay, yeah, I think we are good. I do see a few more questions, but let's tackle those after the webinar. So if you did ask a question and it wasn't answered today, we will be happy to answer it after today's presentation. And thank you so much for everyone attending. And Tammy, do you have a conclusion to say about where people can get stuff?
I do. Thank you so much, John, Zane, and Lewis. We will be announcing our next webinar soon. You can check back to our website under training or be on the lookout for one of our email blasts about upcoming webinar dates for next year. B&B would like to thank you all for your support this year. We look forward to having you join our webinars next year, and I want to wish you all a happy holidays. Thank you so much. Take care, everybody.